We have a quorum. I call the meeting to order. This is a panel on constitutional affairs meeting. Please invite the administration to join us. Item number 1. Information papers is issued since last meeting. Only one from Mr. Kenneth CHAN to the panel chairman. A letter. Item 2. Items for discussion at the next meeting. Let's wait for the administration before we talk about what are on the items, what are on the agenda for the meeting on the 19th of May. Let's welcome Deputy Secretary for Constitutional and Mainland Affairs, Mr. Hon Leung, Principal Assistant Secretary for Constitutional and Mainland Affairs, Ms. Hon Chung, Chief Electoral Officer, Registration and Electoral Office, Mr. Lee Pak Hong, and Deputy Chief Electoral Officer of the Registration and Electoral Officer, Mr. Sham Nam Long. Our next regular meeting is on the 19th of May. What items would you like to discuss in the next meeting? We propose 2 items. First is the submission of the 3rd report by the Hong Kong SAR government to the United Nations under the ICCPR. March last year, the Committee on Human Rights of the United Nations vetted the 3rd report under ICCPR, and they have also made some concluding remarks. They recommend that in a year's time there will be a follow-up report covering universal and equal election, and to ensure that all citizens enjoy civic rights, and in relation to the quality of education on learning Chinese as a second language. In accordance with the established mechanism, we have submitted a follow-up report, which is made available on the website of our Bureau, and it's also been forwarded to the panel. We suggest that this report be discussed in the next meeting. That's the first one. The second one is the progress of elimination of discrimination relating to sexual orientation and gender identity. As you know that the administration endeavors to eliminate discrimination in this regard. In June last year, we have set up our working group on elimination on discrimination. This working group has been in place for a year, so we would like to report to you our progress of work in the next meeting. Any comments, Ms. Emily Lau? In relation to the report, of course, the UN report, of course, I don't have any objections. Just do as you're told as soon as possible. Next month on the 8th, I will attend the ICESER meeting. It's now shortened to 1 day, and I'd like to know when you will come back to report to us. In October, there will be another hearing on the International Convention on Women's Rights. So when are we going to organize a public hearing to invite deputations to give us their views? Any information? Deputy Secretary. Yes, on the 8th of May, there will be a hearing in Geneva under the ICESER. We reckon that in about June, we will revert to this panel to report to you the hearing. In relation to the Convention on Women's Rights, there will be a hearing. The relevant bureau is the Labor and Welfare Bureau. They will revert to the panel in about June or July to give you a report. I hope the clerk will liaise with them. Yes, there may be a different bureau, but they all come back to the same panel. I hope that everything will be done before the summer break. Otherwise, we will not have time to complete everything. I asked the Secretariat to follow them up for us. And hopefully in June we will be able to deal with the ICESCR one. Okay, if there are no other meetings, that will be the items on the agenda. Now, item 3, conduct in contravention of the elections corrupt and illegal conduct ordinance. Deputy Secretary, would you please take us through the paper? Is paper number CB-2 1314/13 to 14 (03). And there is a background brief from the Secretariat. Is paper number (04). Last month, Ms. Priscilla Leung sent a letter to the panel chairman proposing a discussion on the operation of the Elections Corrupt and Illegal Conduct Ordinance. And we will go through with you the different types of corrupt and illegal conduct, the relief mechanism, the penalties, and also the de minimis arrangements. We seek members' views. Let me briefly tell you that in 2000, the ordinance was enacted. It aims at prohibiting corrupt and illegal conduct at elections, regulating election advertisements, EAs, and imposing requirements with respect to expenditure and receipt of donations in connection with elections. The ordinance applies to elections to elect the Chief Executive, members of the Legislative Council, the District Councils, the Election Committee, and the Hang Yi Kuk, the rural representatives, and the chairman or vice chairman or members of the Executive Committee of Rural Committees. The legislation is enforced by the ICAC. It aims to uphold honesty, integrity, and fairness of public elections in Hong Kong. The ordinance prescribed the prohibition of different types of corrupt conduct, illegal conduct, and offences in relation to election return and EAs. And there are also the corresponding penalties. Under the ordinance, there is a relief mechanism in respect of minor illegal conduct and offences relating to EAs and ERs. Since illegal conduct is quite serious, there is no relief mechanism in place. And let me briefly go through the relief mechanism. A candidate, candidate's agent, or any person who has committed an illegal conduct may apply to the Court of First Instance CFI for an order relieving the person from penalties and disqualifications imposed by any electoral law as a consequence of the illegal conduct. And a person who publishes an EA that does not meet the requirements under the ordinance may apply to the CFI for the granting of relief. In relation to ER's election returns, a candidate who is unable or has failed to lodge an ER as required under the ordinance before the end of the permitted period can apply to the CFI for an order allowing him or her to lodge an ER within a further period as the CFI specifies. A candidate can also apply to the CFI for an order enabling him or her to correct any error or false statement in an ER or in any document accompanying the return, or accepting him or her from the requirement to send an invoice or a receipt or a copy of a receipt. Apart from the relief mechanism, in 2001, the administration introduced the de minimis arrangement to deal with minor errors or false statements in ER by administrative means without having to involve the CFI with an application. In other words, the provisions in the ordinance, including the various relief mechanisms, aims at striking a balance on one hand to regulate certain important behavior to ensure the honesty, integrity and fairness of public elections in Hong Kong, and on the other hand to provide relief mechanisms for minor inadvertent or accidental mistakes that are not made due to bad faith. And we will be here to listen to members' views. So far we have 3 members who have raised their hands. I read out their names: Wong Kwong, Ip Kwok Kim and Emily Lau. If there are no others, we also have Helena Wong, 5 minutes each. Mr. Wong Kwong, thank you. In 2008, in the LegCo election, I was elected uncontested. So when I was elected, it was earlier than the geographical election. And when I made the ER, since I'm I'm a member of the DAB, and there were some rallying organized as en masse. As a whole, there are some expenditures related to my standing for election. Afterwards, there was a petition. There was an election petition. I had to spend tens of thousands of dollars to go through the process. There was no relief mechanism, and it was not my intention to engage in any illegal or corrupt conduct. At the time of the deadline, the DAB could not calculate the amount of the expenditure that I have to share. That's why I could not fill in that part. And I now see that mistakes or alterations can be made to the ER within 30 days. Do they include what I mentioned, that is in relation to the election expenditure?
Deputy Secretary, please. Mr. Lee, the Chief Electoral Officer, we are looking at a few issues here. The deadline for submitting the ER wasn't actually set by the REO. It was stated under the election ordinance. All LegCo candidates, whether they are contested or not, they must submit the expense form within 60 days after being elected. And this 60 days start from the day the Gazetto takes place. Under the existing ECICO stipulations for contested elections, the method of calculation for those 60 days is a little bit different. Just now, Mr. Wong said some of his election expenses might be incurred with other candidates. He can apply for a grant, a further postponement to the courts. The relief mechanism introduced in 2011 also covers such scenario, but you have to look at the sum, the total expenditure, and you can update information submitted in the ER to the registration in an electoral office. From what you said, I can totally foresee similar situations in the future. Unfortunately, we still have to apply to the courts. And as you understand, there are litigation costs associated with it, and we have to bear these costs. I think the administrative departments have to take these factors into account. We are sure to see similar scenarios in the future for uncontested elections and discrepancies in the election periods, and there will be problems generated from this period of 60 days. I hope you won't make life hard for the candidates. There is no corrupt or illegal conduct involved, but it will create a lot of hassles for us. The Deputy Secretary, we have heard Mr. Wong's comments. We will consider the situation again. It's no surprise that such scenario occurs, and we will see similar situations in the future, because within a party there will be contested and uncontested members. Yip Kok Him. Thank you, Chairman. On the relevant election ordinance, when we look at what has happened in the past and the experience of other countries, they are very strict and meticulous with their elections ordinance. It's important that we have we have a complete law to safeguard the integrity of our elections, and this is something we should be proud of. However, we have to review certain details. In the 2011 and 2012 elections, we saw a few problems, especially in the district council elections. There are a few issues we have to review. We have had chats with different district councillors under the existing system. Under the existing ECICO is quite stringent. Right now, those who breach the regulations and those who conduct corrupt behaviors are often treated in the same manner. We have talked about election advertisements. They must be submitted within 7 days, otherwise there will be a breach of the regulations. Sometimes these are beyond the ability of the candidates. They are often very busy, and very often they have to rely on volunteers to do the paperwork for them, and inevitably there will be some oversights, and sometimes the candidates cannot meet the paperwork deadlines, and so they could have breached the ordinance. If they are convicted, it's a criminal liability. And this will create problems for the candidates. They are already so busy, and do they really have to be held accountable for the mistakes made by the volunteers? And this would have consequences for the candidates. How do we solve this problem? When we have litigations, we are talking about very large sums of money going to lawyers, etc. If you compare election expenditures with litigation costs, it's unreasonable. And this might deter some candidates from wanting to take part in elections. If an inadvertent mistake will cost them a fortune, this is a problem we have to think about. For slight breach of regulations, do we really have to sue them or held them responsible criminally? I think a review is needed. Who can answer this question? Maybe I will answer, give an answer, and Mr. Lee can supplement. As far as I understand, Mr. Ip is concerned with the submission of EAs during the last elections, including the 2011 DC elections and the 2012 electoral elections. We had measures to facilitate candidates in terms of EAs. For example, they can submit their applications electronically. And this has helped reduce a lot of paperwork for candidates. And the measures seem to be welcomed by the candidates. We have tried to bring convenience in terms of legal arrangements. And is there anything more we can do to help the candidates and their teams? If you have specific recommendations or views, we are very happy to reconsider. Perhaps Mr. Lee can add more on the actual operations of the elections. Mr. Lee, please. I don't have much to add. And in the legal amendment in 2011, as the Deputy Secretary said, we have made amendments based on the comments of electoral members for the ECICO, and we have merged the ECICO with other provisions on election advertisements. As you know, we have two major ordinances. One is the ECICO, and the other is an ordinance under the Registration and Electoral Office. And the major breaches are listed under ECICO, and the regulations on the logistics or execution of the elections are listed under the REO regulations. And the stipulations on the election advertisements are listed under the ordinance of the Election Affairs Commission. Before candidates publish their EAs, they must provide a copy to the Commission. At that time, a lot of candidates sent electronic ads, and that's why we had to update our rules. So we allowed candidates to submit an electronic copy of their EAs one day after publishing, and electronic copies must be made available to the public after one day. And the ordinance has been updated to meet the actual needs. We will further revise our ordinance according to actual needs in the future. I'm more concerned about the penalties. I think this is not a criminal offense, but according to the current penalties, these breaches are considered criminal in nature. Is there any chance to revise these penalties? Right now, we are treating it as a criminal offense. In such situations, there is no criminal intent. So this is what I'm most concerned about. I understand that a lot of regulations have been revised. Some candidates might deliberately give out all their leaflets within a specific time frame so that there's no way to trace what they published. However, my point is, for less serious offenses, they shouldn't be considered criminal offenses, and this should be reflected by the penalties. Deputy Secretary. I will try to respond to this question. We'll certainly go back and look at this scenario to see whether a criminal penalty is warranted. According to my understanding, EAs are very important. In any elections, I'm very sure you're aware that's for very heated elections, the contents of any EAs are very important to the election campaigns of the candidates. So in terms of the system, we are trying to improve transparency overall in order to ensure a transparent election. This is the job of the candidates, and the competing candidates would be very interested in the EAs of their counterparts. So we have to be very careful.
If we criminalize it, there may be a culture that importance attached to this matter may be diminished, and also the basis of that will also be undermined. Next, Ms. Emily Lau. Thank you. Well, we have a discussion today about this because on the 12th of March, Ms. Priscilla Leung sent you a letter. Today is the 23rd of April. We have a discussion in the entire paper. Of course, we're happy to learn that you respect members' letters, but I don't think you give the same treatment to every members. For a lot of the members' letters, they are just thrown to one side. I hope that you will not be partial. I've been asking you to get officials to disclose their interest online. I asked for this to be discussed for 7 or 8 months, and still there was no news about it. Yes, the Deputy Secretary is right. The election culture has been eroded seriously. The election itself is unfair, but we hope that it will be as clean as possible. We should discuss all the matters that are close to our hearts. In relation to the de minimis arrangement, that is those under paragraph 10, you may recall that we have had a lengthy discussion over many years before we have this result. Now that your grandchild is a lot older than he or she was in the past, I just hope that the election system will not be a corrupt one. I thank the Secretary and I thank the clerk for the information given. I asked for some figures related to the number of cases with minor mistakes. In 2011, the DC election, over 800 candidates have committed the mistakes, and 250 of them have been dealt with under the relief mechanism, and over 500 of them have their cases referred to the ICAC. And in the 2011 election, there are 700 such candidates, and 300 of them are dealt with under the relief mechanism, and 400 of them have their cases referred to the ICAC. And in 2012, 100 such candidates have committed mistakes. 22 of them are minor ones, and 76 of them have their cases investigated into by the ICAC. So I want to know, are there any cases that have just exceeded the limit under the de minimis arrangement? That is the one underlined outlined in paragraph 10, say 5,000. Any of the cases that is just over 5,000? So how many of the people on the table have been arrested or have their cases dealt with? These are minor cases, but we're talking about 2011. And what are these cases about? Because their case has not been completely dealt with so far. Well, let me briefly tell you about the progress. The ordinance requires candidates to, within 30 or 60 days, furnish the ER and the ER after the election. The furnished ER will be vetted by the EAC, the Election Affairs Committee. If the mistakes are under the limit of the relief mechanism or the de minimis arrangement, the EAC will ask the candidate to rectify the mistakes. Because under the ordinance, the alterations and the rectification will have to be dealt with within 30 days. And we also will refer some cases to the ICAC to see whether they have to be followed up. If in a certain case the ICAC thinks upon preliminary investigation that it meets the requirement of meets the condition of the relief mechanism, it will be dealt with accordingly. And the number of cases is small, just a handful or just under a dozen or so. The ICAC after looked at the cases, and then they will refer the cases back to us. And we will complete the handling of these cases within about 30 days. And in relation to the cases handled by the ICAC, where the investigation itself is confidential, and I think it's for the ICAC to give you information because I don't have the information. I'm sure that you have the information. I understand that some of them are confidential, but you can't say that all of them are confidential. We're talking about 569 and 443 candidates. You have the duty to tell the LegCo about these cases, whether they have been prosecuted or not. Just give us the number. Give us an entire picture. And how many of them are cases that have just exceeded the conditions of the minimis limit. We're talking about over 1,000 candidates. If necessary, we will give you the information and we'll look them up. I recall from the top of my head that there are about a very few cases that have just exceeded the minimis limit. Most of them have exceeded it by a wide margin. And if it's a failure to lodge a receipt, an invoice, this may be able to be resolved under the relief mechanism. In relation to over 500 and over 400 cases being looked into by the ICAC, I will relay your request to the ICAC to see if they have any further information that they can furnish. Mr. Helena Wong. I know that during elections, a lot of the new media, say for example Facebook, is used. Well, now that you only have to like it, or you change any content, you will have to make a copy of it and furnish it. It's a waste of paper and time. Can we streamline it? Say, ask the candidate to give the name, the address of the Facebook, and then all you have to do is just check it every day to see the changes, instead of asking the candidates to furnish you information of any change, because sometimes when it's being pushed, we don't know to whom it's been being pushed further, maybe to friends. Perhaps you can streamline the approach and require the candidates to just give you the address of the Facebook or the location of the new media for you to check. Paragraph 5. Illegal conduct. I don't really understand what it says. Illegal conduct as prescribed by the Ordinance includes incurring election expenses by persons other than candidates and election expense agents. So any person who is not the candidate or the election expense agent incurring expenditure is an illegal conduct. And it goes on to say that publishing false statement or misleading statements, they may not be published by a candidate or its agent. And is it the case that anyone doing it is an illegal conduct? And during elections, very often we see that some media, say newspapers, are friendly with certain candidates, say Wen Wei and Tai Kung, and they will drum up support for candidates they support, and in some cases they will smear their opponents. And sometimes you won't find election advertisement, the two words on these articles, is written as a newspaper article. The result is that some people will get a positive support, and while others are attacked. Do these count towards the expenditure? And is this an illegal conduct? Is this something to do with press freedom? Perhaps I will first answer the second question of Ms. Wong. The provisions of paragraph 5. It only prescribes the expenses incurred by the candidates. That's why it says that if it's not the candidates themselves or the election expense agents appointed by these candidates, no other person can incur the election expenses for the candidates. And that is the spirit of the provision. And you mentioned that during an election, some medias or newspapers publish articles on candidates' electioneering activities and whether it should count towards an EA or towards the expenditure of the election. It depends on the situation. The ordinance states very clearly that if it enables a candidate to be elected or prevents a candidate from being elected, then it counts towards an election expenditure. And when we look at these newspaper articles or media reports, we will look at whether it is based on facts. So it depends on the facts of the case. And if there are breaches, the ICAC will conduct investigations before they make a decision as to whether to prosecute or not. Back to the first question about EA. In 2011 and 12, during the legislative amendment, we have proposed a way to handle it. If there are instant information on the internet, they only have to supply the URL to the EAC. They only have to give us the hyperlink. They don't have to send us the actual message. That is the current practice. So you're talking about Facebook and web pages. Let me put it this way. Blogs, chat rooms, Facebook. In other words, platforms where you can post messages, you only have to supply us with the hyperlink. You don't have to give us every single message. Next, Mr. Portet. I can only describe it as a departure from reality. They're just trying to regulate something that is not necessary, and doing it excessively. Say, for example, the Apple Daily or the commercial radio, they may support different candidates. On the face of it, there are so many regulations. But you see a large amount of advertisements prior to the election, and it falls outside the regulation of the ordinance. And if you don't use your own name, if you use the name of the group or organization or party you belong to, then it's also outside your control. I think you're just kidding yourself. Ms. Lau mentioned a number of figures. For the DCs, 819, the electrical 100. And I think that everyone who is elected will have a dossier opened, investigating into these candidates. ICAC should only look at serious offenses, say for example bribery. And for the others, they should be dealt with by the EAC. It's just like fixed penalty tickets, parking tickets. And I'm sure that the number will be limited. You don't have to pass the cases to ICACs every single time. It's only a waste of resources. Well, apart from the amount, 5,000, if it falls under this limit, it can be dealt with by the de minimis arrangement. If it's a small amount, and say for example it's only late by 1 day, you can refer the case to the ICAC. So it's not just about the monetary amount. We have to look at the time as well. And that should be a clear distinction between criminal liability and non-criminal offenses. Some of them are just a technical breach. Can it be given summary treatment, say for example fixed penalty ticket? Something like that. Apart from the limit 5,000, can you also introduce a percentage of the election expenses? Instead of just setting it at 5,000, which is quite calcified. And if you don't do anything before the next election, say for example on the internet and apps, how EAs are dealt with, or the use of postal material, you encourage people to destroy trees. You encourage people to use papers in their electioneering activity. You don't encourage people to use electronic means. I think you're just falling. You're falling behind the times, and you're destroying trees.
Who can answer this question? I'd like to add something. You said electronic applications were accepted for EAs, but you were only talking about the approach, but not the timing of application. A lot of the times, candidates have missed deadlines inadvertently. This is a problem we have to tackle. Let me give an overall answer. In terms of the timing or deadline, we will go back and think about it. But the bottom line is we must have deadlines. The only question is whether the deadlines are reasonable. The lodging periods of 30 or 60 days, it can be satisfied in most circumstances. I'm talking about inadvertent mistakes, those who miss the deadlines by mistake. In those cases, what can the candidates do? We will think about this issue. Right now, you mentioned changing criminal offenses into non-criminal ones. We have to be very careful, as I just mentioned, because any changes could have negative impacts on the overall election culture. Under the existing legislation, if you feel that certain items should be made non-criminal in nature, if you have very specific suggestions or recommendations, we can certainly think about them. For the fine ceilings, we have tried to use the principle of convenience when we set those limits, the de minimis limits. And we use our recent elections as reference when we establish the limits. We are happy to review them as needed, but we must be careful. We must strike a balance in order not to destabilize the overall system. For EAs, I totally agree that we have to keep up with the times and new technologies. Recent years, apps have been used by candidates in election campaigns. We will think about them. In terms of legislation, we will review whether there's a need to update them or whether these new technologies have been covered under the existing legislation. Claudia Mo. I'm very puzzled about one thing. In the past, for past LegCo elections, if the audited expenses are different from the declared expenditures, even if the differences are very small, the investigators or ICAC would come after me. You are just wasting the time of the ICAC. They should be looking at the big players and not these small things. The relief amount is $3,000. I don't know how you came up with this sum. You are using two offices to try to get back the difference of $3,000 for geographical constituencies. They often spend upwards of $1 million in their election campaigns. If if you set aside a small penalty, you can save the ICAC from deploying their very precious manpower. When we establish the limits, these limits were established according to actual needs in recent elections. If we adopt a sliding scale of 1 to 10%, we can think about this approach, but still we have to be careful. If we are talking about a big upper limit, the relief limits would also increase correspondingly. This is something we must be careful about. When we talk about electrical elections, we have 70 places. You are making life very difficult for everyone. And I'd like to follow up on Paul Chair's question. Every election has a time frame. And 2 or 3 months before a campaign, you spend hundreds of thousands of dollars in billboards, and those are not taken into account. So where is the fairness? As far as I know, the EAs might not only be incurred by the candidates. Can you tell us in detail how do you calculate the very expensive election advertisement costs? I'm not a legal expert. I will provide details after this meeting. According to the legislation, any costs incurred in promoting a candidate will be taken into account. Next, Priscilla Leung. I wrote a letter to ask for a review of the ordinance. Some of our friends, like Mr. Leung has taken part in a DC election. He was very tired and he spent a lot of money on litigation. He was lucky that he didn't breach any of the rules. However, I do think that the ECICO is trying to discourage candidates from taking part in elections. There are a lot of nitty-gritty which consumes a lot of energy and time from the candidates. And it has encouraged political wars, per se, between the candidates. The upper limit for election costs is $53,800. As Priscilla Leung said, sometimes we have to argue over very small differences. Sometimes there are very small mistakes in wordings, and the investigators would come knocking on our doors. So I wonder whether they have nothing better to do, and they have to spend so much time investigating on these cases. So for the administrative breaches, the administration said they would be careful in they would execute these rules carefully. You should focus your energies on real criminal breaches. For admin errors, these admin errors should be taken care of by REO, by fines or whatever. For severe breaches, you can disqualify the candidates, and the REO can introduce legal experts. And we should not turn to these relief mechanisms all the time, because the judges might not be very familiar with election ordinances, and we should not discourage these candidates. If you disqualify the candidates and they are not satisfied, they can take matters to the courts, but this is their choice. I think the REO and the ICAC should have a proper division of labor. You should not waste public money and our time. For DC elections, we face there are a lot of district councillors, and they have no resources. Not everyone is backed by a big political party, and independent candidates often struggle, and they have to rely on volunteers to look at the volunteers, and these volunteers have no legal training. So the consequences might be that they are disqualified. And this relief mechanism wastes a lot of resources and time. So my personal opinion that it's not very healthy.
A lot of people become scared. I remember in 2011, there was a lengthy discussion. I read through the minutes. It says that written consent forms are to protect candidates, just in case these people say that, well, I actually did not give my consent. But it only creates more trouble for candidates. So we need to have measures that encourage candidates and facilitate them. And I think there should be a clearer division of labor between the ICAC and the EAC. ICAC should not be entangled in trivial matters like this. We have replied in the earlier part of the meeting to some of the questions in relation to decriminalizing certain acts or turning them into administrative breach. If it's an administrative breach without criminal liability, then the incentive for compliance will be reduced. In relation to ICAC investigations, I've heard from members that ICAC are too strict and too vigorous in their investigation. No, I think that they have too much time on their hands. Well, I can't answer on behalf of the ICAC, but from what I gathered, they will look into the facts of the case and they exercise discretion. But I was telling you about some specific cases. I can't give you more information because they are the law enforcement agency, and as to whether in certain cases they have been too strict or unreasonable, I think a more practical way is for you to refer these cases to us, and then we will refer these cases to the ICAC, and we'll find ways to see if the investigation can be improved in any way. Follow up, but your time is up. Well, under common law, there is mens rea. You need evidence. But that is not the case now. Whatever the case is a criminal offense, and the case will have to go to court. I know that you have to be careful, but we're not asking for an improvement. Your answer fails to address our concern. Members from different political parties have the same experience, and we all think that there should be some amendments to the law. Mrs. Regina Ip. I thank the CMAB Pro for providing this detailed information paper to response to Ms. Leung's suggestion in relation to the $50,000 limit of election expenditure. That is for the DC, and it's a very small amount for DC elections. Compared to the DC election, electoral elections have at least 1 million. For a DC election, there are about 7,000 to 8,000 voters. Say the South Horizon's constituency. There are about 7,000 voters, so you only have $8 to spend on each voter. And sometimes you're smeared and you will have to print leaflets to clarify the situation. And I think with such a low limit, it will affect the position of candidates and their ability to clear their name. Say, for example, the recent by-election, 7,000 voters, only about 1,000 of them supply email addresses. And if more of them supply me with an email address, I don't have to print so much. I don't know whether you take into account an inflation. Maybe for every DC member, we will be given $10 per voter. And I think that is a reasonable amount. And I've also mentioned a case to Mr. Leung, the DS. Well, in relation to the declaration of election expenses, we have a deadline. And if there is unused donation, we will have to surrender that. But if I haven't worked out the election expenses, how can I find out how much I will have to fork out from the donation? And sometimes I will have to donate more than I'm supposed to, and then I'll have to engage a lawyer to deal with the ICAC. I haven't even reported my election expenditure. How am I supposed to know how much I'm supposed to surrender from the donations? Yes. We will go through the legislation to see if there is room for improvement when it comes to the time limit. About the first point, the ceiling of election expenditure for DC, the 53,800, that's the limit for 2011. Before every election, we will review the election expenditure limit. So before November 2015, we will conduct a similar review. Will you consider have an index-linked or inflation-linked system? Well, will you consider that? Because prices have increased a lot over the years. You've never been in an election, so you don't know the tough times we have. Yes, we will consider that. Inflation is one of the things we will consider. I think it should be higher than inflation, but at least it should be the same as inflation. Inflation is only about 3% or so. But well, anyway, just conduct some studies to find out what is the reasonable expenditure in an election. Last one, Mr. Chung Kwok Pen. For DC, $50,000 or so. I think it will be used up if you print 2 rounds of materials. All these adjustments and amendments are trivial in nature. will they maybe introduce a significant change to the election expenditure? I'm not talking about like those in Taiwan or the US where there is a no limit. Sometimes before an election, some candidates have already done certain things. And you can't pin them down for having done these things. And now that we have the new forms of media, would you maybe consider relaxing TV commercials as well? In mature countries, this is something that is widely accepted. So if you just open up these new forms of advertisements, yes, for independent candidates or candidates that have no affiliation with bigger organizations, it may be difficult for them to have the resources. This may change the ways political parties or groups conduct the election, and you should move ahead with the times. This is a suggestion. Any reply? So far, no. I thank Mr. Chung for his suggestion, and we will also take that into account. Now we need to finish this item. We now move on to the next item. Item 4. Briefing by the chairman of the EOC, Equal Opportunities Commission. We have about 5 or 6 members who want to ask questions. We've been talking about this in 2012, at least come back with a timetable and a roadmap. We had a discussion in 2012 and there was a minute. We have to talk about this again this year. There is improvement, but we're not talking about just improvement. We have given specific requests. Say, for example, the REO should take up more work, and instead of mechanically transferring the cases to the ICAC. You were late, and some of the points have been replied to. So there is no timetable. You need to give time to mull things over. The DS will report to us in due course before the next election. Yes, please. Next item. Yes, the clerk is writing them down. Just keep your hands up. Let's welcome Chairperson of the EOC, Dr. York Chow, and Chief Legal Counsel, Mr. Herman Poon. Mr. Chow, Dr. Chow, you have supplied us a paper, CB bracket 21314/13 to 14 bracket 05. And the Secretariat prepared an updated background brief, paper number bracket 06. And first, ask Dr. Chow to take us through the paper. Thank you. Thank you, Chairman and members. I'm glad to be here today to tell you the latest information about the EOC, our the progress of work, and new work and challenges. Through our work, we hope to mainstream equal opportunities and introduce changes in society. And these values will be the basis of new policies. In the formulation or changes to policy, there should be a comprehensive assessment. These changes should be studied into to find out how it will change our society. Mainstreaming equal opportunity requires continuous and hard work. And we also need support of stakeholders, including the administration, district councillors, community leaders, NGOs, society dignitaries, and the LegCo. We see that members of the public find it more and more acceptable to have more and more accept equal opportunities. And sometimes members of the public and or some organizations have done a lot of work to promote equal opportunities. This should be the way forward. We should actively promote equal opportunities. And we should not be complacent simply because there are no breaches of the law. And over the years, through our publicity and education program, we have effected a positive impact. We will continue to discuss with stakeholders on the various issues. Over the years, in order to protect our pluralistic and diversified society, we have to closely monitor equal opportunity issues. We also look into matters that breach the 4 discrimination ordinances. We will also look into ways to better improve our functions. Apart from enforcing the discrimination ordinances, we also study into various discrimination issues and actively liaise with stakeholders. The recent legislative amendment on marriage ordinance and in relation to the LGBTIG new immigrants, mainlanders, they may face discrimination. We participate in dealing with all these issues.
To tackle these problems in the coming future, we will conduct studies on age discrimination. And we will look at the issue of mainlanders and new immigrants, and we will consult the public on their views. The purpose of the legal review is to keep the discrimination ordinances up to date and to enhance the protection offered by the ordinances. And these are some of our recent works. And we have consulted the EOC's government's committee and the major stakeholders. And as you can see, we have a lot of work. We are not a big organization. We only have about 90 staff, and it's obvious that we need more funds to execute our new projects and initiatives. You can refer to our papers for details. Our key challenges is that our office is not owned by EOC, and in the past we have been using public money, and as such we have to be prudent. We cannot control the rental market for offices. The rents have gone up tremendously, and we have to use our turn to our reserves to pay rents, and we have to solve this problem in the long run, because we are here for the EOC. It's a permanent organization, so we have to solve the problem of our office. So hopefully members will support our funding application to the government for a permanent office, and we hope we have enough resources to tackle our future work. I'd also like to take this chance to thank our colleagues at the EOC and the 2 members in our governance committee who are also LegCo members, and the comments of LegCo members and the public also encourage us to improve. Thank you, Dr. Chow. 12 members would like to ask questions. Lee Chak-yan, Paul Chair, Helena Wong, Chen Chi-chun, Gary Fan, Claudia Mo, Emily Lau, Chung Kok Ban, Yu Si Wing, Regina Yip. Anyone else? If not, 4 minutes each, please, because of time limits. Mr. Lee Chak-yan. I think the EOC plays a very important role in fighting discrimination. Just now, the chairman said they will conduct studies on age and sexual orientation discrimination. We have been pushing for a single legislation to tackle all types of discriminations. So right now, would you aim to tackle all types of discriminations such as age, sexual orientation, new immigrants? Would you incorporate all these discriminations under a single legislation? Are you going in this direction? Do you see any resistance from the government, especially since the government doesn't seem to have a stance? The labor unions have been discussing with you on the issue of sexual harassment from customers. I think we need legislation. I'd just like to know when the legislation can be in place and what does the schedule look like. You have consulted workers' unions for flight attendants. They have been suffering from sexual harassment on flight. I'm not sure how the legislation can protect flight attendants on flights. And for flights heading towards Hong Kong, will those flights be protected, or the flights have to have landed in Hong Kong before the flight attendants can be protected? So thank you very much for your question. The review of the four discrimination laws. We are doing translation work, and a public consultation will be in place in the third quarter this year. And we are looking at the possibility of merging these four discrimination laws into a single legislation. We will conduct studies and consultation, and we will look at age discrimination in the workplace, and we will conclude these works in the next 12 months. We need consistency among the four laws. In the past, the government hasn't reviewed the overall ordinance, and as such, we will come up with recommendations before we seek the views of the government, and we will let the government know of our concerns. And on sexual harassment, especially towards flight attendants, we think the government will put legislation in place very soon, and we have conducted studies with airlines and the airline staff. We have also consulted F&B premises. And would it only cover local employees or airline staff? We feel that this is a basic protection level. And what about flights coming to Hong Kong? I think we can further discuss later. Helena Wong. I have two questions. How does the EOC execute discrimination education in schools? Do you carry out promotion works in schools? And the second, on integrated education, especially for ethnic minorities. When the minorities get along with other students, do parents and students know about the anti-discrimination policies. We have received complaints from parents who don't speak Chinese or English. They are not aware of the subsidy schemes, and they haven't received any information. So can the EOC find out how schools communicate with non-Chinese speaking parents, and how do you ensure that they are receiving equal opportunities? And this morning we talked about the marriage amendment ordinance, and we talked about transgender persons. You mentioned you will look at sexual orientation discrimination. The government has set up a cross-department task force on sexual discrimination. Are they going to invite you into the task force? If not, would you recommend who should be in this task force, or would the EOC initiate another platform and invite LGBTI representatives or sexual orientation experts to tackle this issue? Is the government and the EOC working separately on this issue? First, on the education in schools. After a study last year, we find that sexual discrimination is very serious in schools. Since March 2013, we have conducted a study, and in the second half of last year, we have worked with the EDB to come up with a framework for sexual discrimination in the campus. We have launched 5 major consultation sessions in schools, and we have informed the school sponsoring bodies of the ordinance. We will continue to work with primary schools, secondary schools, and tertiary institutes on training efforts, and we will conduct another study soon to look at the results of our training efforts. And on integrated education, we are looking at students with learning problems, and for ethnic minorities. In the budget this year, the government set aside more than $4 million to set up a new team of 7 persons, and we hope this new team can reach out to different institutes and organizations to provide services and carry out public education and further policy research, etc. And at the right moment, we will continue to monitor the government's efforts and execution. Time is very limited, so perhaps I will talk about transgender persons. In the past year, I have met different relevant persons and listened to their plights, and I have consulted the DOJ on this issue. A lot of people have misunderstandings or stereotypes on these persons. We want to listen to the needs of these minority transgender persons, and we are seeking to understand how they correct their genders. We will continue discussions, and I have provided comments to the task force under DOJ and on what they can do. Mr. CHAN. I'd like to discuss a very concrete issue. I think the DOC warrants more funding. last year I told the EOC if they need more money, they should turn to LegCo. So I support the application. The chairman said there would be an increase in recurrent funding, but you haven't mentioned the scope of the increase. You are reporting on the 3-year strategic work priorities, and 3 years have passed very quickly. I see the EOC has done a lot on legal protection for sexual minorities, but we haven't seen very concrete results yet. I'd like to talk about paragraph 6B. And it mentioned whether protection should be extended to cover de facto relationships or the duty of service providers and employers to provide reasonable accommodation for people with disability. And on marriage, our traditional understanding is that there would be children and relationships, but all that's missing is formal registration. So what is our understanding of a marriage? Should it cover long-term relationships? In recent years, some countries have allowed same-sex marriages, and should this be taken into account? And for we can look at the opinion of civil unions and religious leaders. They are agreeing to legislation on long-term relationships. And will civil union be a direction to go?
Dr. Chan, first of all, I thank you for your support of our work. Secondly, in relation to issues related to sexual minorities, we think there is a little understanding of Hong Kong public of this group. In the past year or so, we've been meeting with lots of groups. We have accepted interviews with the media and the press to send out right messages about the right idea. When we introduce a sexual discrimination ordinance of sexual minorities, we will take all of their views into account. We have engaged a consultant to conduct some studies, to take up a public consultation, and to consult sexual minorities. In the discrimination law review, in particular of family position and sex and sexual discrimination, in relation to marriages, we include men and women, because currently under the marriage ordinance is a marriage between a man and a woman. It may change in the future, we don't know, but that is the current situation. And in relation to civil union and same-sex marriage, discussions have just started. From the stance of protection of human rights, we would like the public, we would like society to discuss these issues, and we cannot dodge them. And in a lot of overseas jurisdictions, there are same-sex marriages. Hong Kong is a place where there is a traditional values and ideas, but we can't avoid discussion because we need to protect every single person and afford them with legal rights and protections, whether it is legal protection of a relationship that is similar to a marriage. Mr. Garifan, this morning in the public hearing of the Marriage Amendment Ordinance, someone came to speak on the recognition of the work of the EOC on sexual minorities, elimination of discrimination. I share his view, and this is an important year. I will say what is right and criticize what is wrong. Dr. Chow recently in a campaign, in an anti-locust campaign, Dr. Chow and some bureau secretaries came out to criticize the campaign. Dr. Chow was one of them. In paragraph 6, it says that in the third quarter this year, the EOC will review the scope of discrimination law, and it include whether the existing provisions should include mainlanders and new migrants. Dr. Chow recently came out to say that, well, now that the anti-mainlanders campaign has subsided, and then you will have to review our position to consider expansion of the scope to mainlanders and new migrants. Dr. Chow, you're an important person holding an important office. You will have to be very careful with what you say, and when it comes to easily changing your stance. You came out again to say something different. This doesn't help the situation, and this will undermine your credibility and authority. What I want to ask is, according to your internal review and a study, what basis do you have to expand the race discrimination ordinance to cover same race? In the UN International Covenant against all forms of discrimination, it talks about discrimination of someone who is of a different race, ethnicity, etc., etc. Why would you so carelessly say that you should change the definition of race discrimination? Dr. Chow, I would like to say that it's always been our stance that we will pay attention to situation that is aggravating. We will consider whether we need to legislate to prevent the situation from getting worse. Yes, I said that we need to consider whether the scope of the race discrimination ordinance should be expanded to same race. I said yesterday that since we have made our stance clear, there has been a lot of comments, media reports, comments from the academics that they don't want to see Hong Kong people discriminating against mainlanders. In the past few weeks, we see that the behavior, the discriminating words against mainlanders have subsided. Of course, if it aggravates, of course we don't necessarily have to legislate against it, but if necessary we should consider it, and it should always be there, ready to be used depending on the situation, and whether it should be used depends on how the situation pans out. Next, Ms. Claudia Mo. Thank you. Well, I used to really appreciate what Dr. Chow has done, in particular his fight for equal rights of people with different sexual orientation. That's very moving. But on the other hand, he does not follow the footsteps of his predecessor, Mr. Leung, that is, in the fight for equal opportunities of ethnic minority students. And you now say that hundreds of millions of dollars will be spent on improving Chinese language as a second language teaching. And you think that that will be work done. I'm very shocked that you said that under the Race Discrimination Ordinance, you should make a distinction between mainlanders and Hong Kongers. This is not just a careless. It's it is irresponsible as well, because race is about race, ethnicity, and skin color. How do you make a distinction between Hong Kongers and mainlanders? One is a resident, the other one is a visitor. Well, under the umbrella Chinese, there are different ethnicities. We have Han, we have Mongolian, and many different tribes. You're talking about race discrimination among the same race. This is worrying. And you have turned this round. You want to use the Race Discrimination Ordinance to protect new migrants. I don't know whether you're doing something bad with good intentions. New immigrants are Hong Kongers. And you say that they should not be discriminated against, but they are Hong Kongers. What you say, in effect, is positive discrimination. You have mixed up the ideas. If you want to make a distinction of the same people under the Race Discrimination Ordinance, well then, have you thought about Pakistanis, Indian, here in Hong Kong? And there is a long history of sectarian conflicts among them. And how do you protect them? Under the basic law, there is no definition of Hong Kongers. And now, well, you say that there should be race discrimination protection of new migrants, but they are Hong Kongers. Dr. Yok Chow. Miss Mo, if you have time, I'd like to invite you to talk to new migrant groups to understand their problems. No, I think he's trying to muddle the water to circumvent my question. Of course, some new migrants are subject to discrimination, but you have turned it round. You have in effect said that they are not Hong Kongers. What are you talking about when it comes to expanding the scope of the ordinance? I think you have you are suffering from some mental disorder. I think this is insulting, Dr. Chow. Well, I don't really agree with what Miss Mo said, especially when she referred to my mental condition. Next, Miss Emily Leung. Yes, we should not use such words. Next month there will be a UN hearing. Chairman, you don't go, but you send someone else to go there. And of course, it will be a topic whether new migrants are discriminated against. Over the years, there has been records in the UN hearing, and we can refer to them. We will see. We will watch you speak for the underprivileged. There are 4 discrimination ordinances, and for some issues that are outside these 4 ordinances, so you can also speak on them as well, because you're expected by Hong Kong people to do so. You should do so without fear. You should speak what is right. I'm sure that your ears have gone red because you've been spoken of this morning, all morning. I think you should speak to people who are speaking for you and speaking against you as well. He mentioned about his office. Well, in general, when you want to seek funding approval for an office, most likely it's doomed. The EOC came for the same thing many years ago. It was Anna Wu, I think. And she was accused of biting the hand that feeds them. So it's gone down the drain. But I think that the Privacy Commissioner has his own office. I see that you have not given them additional funding. Members asked them to do more. And they talk about $22 per square foot, and it's now increased to $32 and $42. And it said that they're eating into the reserve. You want them to reduce their manpower from 90 to 70? I think in general there are more praises than criticism of the work of the EOC, and the only thing they're accused of is not doing enough. And if on top of everything they have to move office, it will be more work for them. Now that the EOC has raised this issue, I see that they have spent a lot of ink on this. I'm sure there were a lot of discussions internally. Chairman, you should speak on the top of your voice of things that are right, than to say things that you should, and speak for the underprivileged.
I'll first talk about the office of the EOC. As far as we know, they used their own money, their own funds for their office. The office of the Ombudsman and the EOC, their office are both on rents at the moment. Do you understand my question? Yes. We understand that the rents for offices have gone up a lot in recent years, and for the EOC and office of the Privacy Commissioner, we will support the rental of their offices. For the long run, do we need permanent offices for these institutions? We are considering the possibility. So how much longer do we have to wait? The rents will go up to $42 per feet, and they have no money. So what do you want them to do? The office of the Privacy Commissioner and the EOC, there are permanent agreements, and they do have reserves in hand. We understand that this is not the long-term solution, because it would put strains on the financial position of these institutions. I hope they can report on their progress in a few months, so perhaps Dr. Chow can help. Chairman, we are happy to use our reserves in new projects, but not to pay rent. We used to pay $22 per feet, and now we are paying $42, and the rates can yet go up in the future. So we might spend more than we expected in terms of rent, but not in other expenses. Gary Fan, I'm sorry you could not speak in the second round. We have 8 more questions because our meeting must end by 4:30. So we can only take in 8 more questions. Priscilla Leung. I'm very positive with the work of the EOC until Dr. Chow talked about transgender marriage. I think he's not being responsible, and he has not discussed with the relevant groups. You mentioned using a single legislation to tackle all problems. I think this is a very naive view, and this is not possible. I certainly think there are a lot of questions. I have a lot of views. I do think we need to protect mainlanders and tourists, even if some of them might be permanent residents of Hong Kong. We have to look at the issue objectively. We have been talking about rights of marriage, and we actually want to review the whole marriage system. And you wrote a very controversial article. Once the legislation is in place, even schools with religious backgrounds cannot be exempted. You haven't mentioned cases in other countries. During one of our meetings, we mentioned a case in the UK. There was a Christian couple. Their religion is against same-sex marriage, and the courts ruled that they cannot adopt a child. Are you just looking at transgender persons and not looking, and you're not taking care of other groups, other kinds of sexual minorities? The legislation is not yet in place for schools with Christian backgrounds. You are interfering with the spirits of the schools. Under Article 32 of the Basic Law and Section 18(4) of ICCPR, their rights should be protected. You are depriving these groups of their rights. Even according to the UN conventions, you have to ensure religious equality. The freedom of speech and religious freedom of the schools should be safeguarded, and now you said those schools will not be exempted from the equal opportunities legislation. So where is the equality or fairness? Have you considered negative consequences of the legislations? Dr. Chow. Should the religious principles of the school sponsoring bodies be respected? This morning we had 60 or so people here discussing the issue of transgender persons. What about the case of reverse discrimination? What about the case in UK? Can you look at such cases? We do study cases from different countries, and however, the context of different cases are very different. I have mentioned this point in the Sexual Discrimination Committee. We cannot take one case and extend it to all types of scenarios. We have to look at the context of each case. Please don't stop him. Time's up. We object. We do not agree with the direction adopted by the UK, and I hope the chairman would understand. Ms. Chen Yunhan. Dr. Chow is very experienced. For such controversial issue, we are sure to have a split of opinion. We mentioned discrimination against new immigrants. We have received complaints from new immigrants. They are really suffering. I think this issue should be discussed in EOC. there is a split of opinion in the society. However, this issue must still be discussed for the long-term future of Hong Kong. For the issue of rents, I hope the administration can really help them. The rent has gone up to $70 to $42 per feet. How can they continue? When the EOC was first established, we expected them to receive lots of cases. You receive a lot of cases on sexual discrimination against pregnant mothers. There hasn't been enough support to these people. For institutions who ask for the establishment of the EOC, we have asked for an independent legal institution to take care of these cases. I think we do need to review on several issues. First is the rent. Second, an independent court for these cases. As we see more and more cases, there must be enough support in the back. We are disappointed with the EOC on a few fronts. First, we have had the sexual discrimination ordinance for a long time. However, in terms of execution, women or pregnant mothers who need to be protected aren't offered the necessary protection. I hope we can review the sexual discrimination ordinance after so many years. We still have so many cases out of all the complaints received by the EOC. Second, on age discrimination, I'm very happy that you're working on it. However, have you collected enough information? We have been discussing this issue in LegCo for years and years, and it has been ignored by the EOC. So we must tackle the issue of age discrimination. Do you want him to answer this question, or you can use your remaining time? My question is, for the sexual discrimination ordinance for pregnant mothers, the problem is very serious. How do you solve this problem? This is a civil law. Employers might not understand their liability or risks. So we would carry out mediation efforts for women who are fired or relocated to a different position. Such scenarios do occur, and we have to actively tackle these problems. We have met a number of employee organizations and educate them on the issue. We are not just talking about mediation or compensations. We need to educate them on the entire issue. Mr. Chung Kwok Ban, I have a question for Dr. Chow. For the consultation and viability studies of the legislation, should the EOC be neutral? In our sexual discrimination panel, we hired a consultancy to carry out the studies. And they are more or less neutral. From the EOC's point of view, we would certainly continue to look at the voices of minorities and marginalized people. we would educate the public on their on the challenges they face. So we will be as neutral as possible and look at issues from different angles. The problem is, as some of the members have said, Dr. Chow seems to be biased already, and the feeling is that the EOC is not equal or neutral anymore. I think this situation is unfair to the EOC because the chairman has said something not very neutral. I'm talking about the chairman of the EOC, Dr. Chow. He said they're learning from other countries. But still, Hong Kong is a Chinese society, and our situation is unique. Do we necessarily have to copy other countries for the issue of election expenditures? They certainly are not thinking that we have to do something just because someone else is doing it. Hong Kong is a Chinese society, and we have to look at our unique situation. These issues aren't initiated by the EOC, but by the society in general. So under the principle of equal opportunities, we are trying to solve problems for the society. Mr. Poche, we have 3 questions.
On the gender identity and sexual orientation. Well, I'm a member of the EOC. This morning we heard from over 60 deputations and individuals on complex issues. In my impression is that there is no importance attached to the work done by the EOC, and very often the EOC was not consulted. The EOC itself should play an important role on this issue, and I think that they have not been properly consulted. I don't agree with Chung Kok Pen. When it comes to changing customs, well, it's very difficult. The EOC is a pioneer, so they have to brave a lot of storms. That's the reason why the administration should give more importance to the work of the EOC and give them more resources. On office, 42 was an old price. It was 2011. I think in April this year, this will be more than 50. Maybe we can use the resources, say in the west wing of the CGO, of the old CGO, so that they don't have to tap into their reserves to pay rent, and they can have their own resources released to do something proper and more important. When it comes to visitors, new migrants, and race. Well, when it comes to discrimination against visitors, new migrants, well, in overseas countries, hate speech is prohibited. But we see that in Hong Kong, that hasn't subsided at all. Last week, there was the incident in Mong Kok when a kid was relieving himself in public. This has affected the image of Hong Kong as an advanced and civilized place. Well, I don't completely agree that it can be properly dealt with under the Race Discrimination Ordinance, but I believe that under the International Convention, anything related to hate speech targeting the origin of certain people should be prohibited. When it comes to race discrimination, usually it's about xenophobia. In the International Convention, apart from race, citizenship, say if you're not a citizen and you're discriminated against, that will be under the scope of the International Convention. In Australia, in their race discrimination law, there are provisions preventing this discrimination against migrants. So when it comes to dealing with discrimination against new migrants under the Race Discrimination Ordinance, this will be appropriate. Mr. Che mentions hate speech is related to the International Convention. Next, Mr. Yu Si-wing. I also want to talk about public consultation in the third quarter, mentioned in paragraph 6. I agree that when it comes to discrimination against mainlanders and new migrants, yes, there should be public consultation. We see that there has been a recent spate of scolding, discrimination, and harsh treatment towards mainland visitors. We are all Chinese, and sometimes public opinions form. And as to whether this should be expanded under the race discrimination, of course, we will just see how it pans out. About the office, it seems that there are only about 10 staff members. 90. Yes, you have 90 staff members. How much space are they using? It seems that it will cost about $4 million a year for rent. Yes, that's during SARS. Do you have? Maybe you should give us the calculations about how much space you will need in the future and how much it will take to buy your own premises. And maybe if you take into account rental, depreciation, it will be more cost effective to buy your own property. Give us more information. What's your view anyway, Dr. Chow? Well, we have 90 or so staff members. We're all housed in the same office. Currently, if my maths is right, it costs us about $9 million. When we first moved there, it was about $5 million. So you see that rent has almost doubled. We have $101 million. This accounts for 9%, which is a significant share. It's high time for the EOC to have its own office. So we're talking about $200 million. If you spend $200 million to buy your own property, I think it's worth considering. When does the lease expire? End of this year. Currently, we're negotiating with the landlord about a renewal. So perhaps the administration can make a decision as to whether DLC should purchase its own property and then seek funding approval from the LegCo. It seems that now you've made a suggestion and our discussion will be meaningless. Or we have to go through the policy bureau and the established procedure in the government before we go to the legislature. We have to follow the established procedure. Next, Ms. Sitho. Protection of the rights of minorities is hard work that wins little applause. Because if you get applause, then there won't be the situation when minorities are discriminated against in the first place. I'm glad that these discrimination laws have been passed before society gets so angry. Dr. Chow has been the chairman for 2 years, and I think he now fully realized that it's more important to change culture and customs. Well, legislation cannot stop hate speech, but without it, without it, nothing is done. I think we need to help society understand what is discrimination, what is reverse discrimination, and what is justice. Sometimes ideas are mixed up and people unwittingly discriminate against a certain group of people. We heard this morning when it comes to discrimination, sexual orientation, the first thing they say is that I'm very caring, I am not prejudiced, and then later they will go on to say something that is seriously discriminatory. So when it comes to publicity and education, can the EOC do more apart from promoting legislation? Because this is very important. Can they do more to dispel misunderstandings and unreasonable fear, whether it's targeting against a certain group of people that threatens your very core belief, or to dispel fear so that society doesn't have to find scapegoats, so that society will be a safe place for minorities. And society will not erode because of fear. Well, I've been the chairman for a year. We've done a lot of work. I've done some surveys. I have attended the 227 community events and have had 72 interviews and made speeches 93 times. And I've also met with 212 community organizations and 112 meetings. So that's a lot of work. The work of one person is not enough. Of course, we need the work of the entire commission. The most important thing is to mainstream equal opportunity. And it's not just our words. It should be the government, the business sector, NGOs, legislators, district councillors will have the same principle in mind. It takes more than one person to do the work. We try to influence others. We will continue with our work. Last one, Mr. Leung. I want to lodge a complaint, Dr. Chow. 1,600 people discriminating against 3 million. Is it reasonable or not? What do you say? 1,600 people picks a person before others can make a choice. Isn't this discrimination? And it's serious discrimination. It's discrimination in a discrimination, because they first discriminate against certain people before they are screened. So there are 2 screenings. Is it a philosophical problem? I know what you're talking about. Of course. Mr. Tam spoke on the radio this morning. Well, my driver's hands were shaking when he heard you, and I implored him not to let his hands shake because it's still quite some time before that happens, and he's driving. I do think that this is serious discrimination, and I'm afraid that this cannot be eliminated within a short time. I have a question to ask you. Do we need a restructuring of the EOC? That is, for different issues, that there will be different chairperson, and you will be the president or something. I'm serious. I know that you have a bad impression on me. In the past, you've been scolding me a lot, but I'm serious today. It's difficult to change customs because human beings is an animal of habit. So if you want them to change the habit, it's difficult. We're dealing with problems that have been in place for a very long time. Hong Kong is a restless place. Hong Kong people think that we are more important than others, so they magnify the importance of their own problem, and they look for scapegoats. If you read the history of the rise of Nazis, then you will see how gypsies were discriminated against. So it's necessary for you to have a restructuring of the commission, whether members will be or chairman will be elected in the community, and then they will head the subgroups, and you will head all of them. I think it will be easier for the EOC to perform its function so that you can oversee everything.
Thank you very much for your comments. First of all, I don't feel painful at all because I'm doing something very meaningful. But it's very heavy work for you. I'm very interested in the work. You have taken part in 250. You have initiated 251 social community events. There is a screening process. You can your role can be like a director overseeing the work of different committees. And there's a few benefits. First, you can make sure that the representatives are from the community. The work of the EOC relies on a lot of members of the community. We partner a lot of members of the community to drive change. And we can certainly consider inviting even more external representatives. We have 16 members, and a lot of them are very passionate with the work. Time is up for the meeting, so I'd like to thank Dr. Chow for attending the meeting, and I think everyone's very passionate about this topic as well. So that's all for the meeting. Any other business? If not, the next meeting will be on the 19th of May